for the last word. Was the Supreme Court right to give Sanjay Dutt 4 extra weeks to surrender and go to jail? Or was this unwarranted special treatment? That's with two senior and highly regarded Supreme Court lawyers, Raju Ramachandran in studio and Aryama Sundaram joining us from his residence. We also have the director of one of Sanjay Dutt's unfinished films, Ungli, Rensal De Silva. And joining us shortly, the editorial page editor of The Telegraph, Rudrangshu Mukherjee. Raju Ramachandran, let me ask you bluntly. In your eyes, was the Supreme Court right to give Sanjay Dutt 4 extra weeks relief before he surrenders and goes to jail? Or does this amount to unjustified indulgence verging towards bias or favoritism?
I wouldn't call it bias or favoritism, but I am clear in my mind that the Supreme Court went egregiously wrong. For the reason that the normal rule is that once a conviction is upheld, you are to go to jail straight away. An indulgence has been shown on one occasion. That is on the day when the judgment was pronounced.
I.e. the first 4 weeks.
That's right. That itself was an indulgence.
This is exacerbating it.
This is the second indulgence which was not necessary at all and which was not warranted. I think this will set a wrong precedent, and it's not going to be possible for the court to grant it every time, and then odious comparisons will be drawn.
So the Supreme Court has actually tied itself up in knots.
I think so.
Aryama Sundaram, yesterday, 3 other people, including Zebunissa Kazi, were refused relief, although they applied on different grounds. They wanted their surrender delayed till the president hears their pardon pleas. Sanjay wanted relief to complete his films. My question to you is, was the Supreme Court right to make a distinction in the 2 cases?
Of course. You made the distinction yourself. The 2 were totally different requests. Now let's understand one thing, because I want to take off on what Raju just said.
Actually, I wasn't making a distinction myself. I was simply pointing out that Zebu Nissa's plea that she should be given reprieve till the president... Well, it's not really, because her plea that she should be given relief till her pardon is decided is also a humanitarian plea, just as much as Sanjay's is. Therefore, I ask you the question again, was the Supreme Court right to create a distinction where none should exist?
I don't agree with you that none should exist. I believe the Supreme Court was right. But as to whether they felt on the facts of the case it ought to be granted or not was an exercise of judicial discretion. The power to exercise such judicial discretion is available with the court, and I do not find anything abysmally wrong with this decision. And let me explain to you why I say so. It has always been accepted that on various grounds, interim bail is given even when a person is undergoing a sentence and is in jail. There could be any number of reasons why it's given. It could be to cremate a father, it could be to get a daughter married. There are many reasons why this is done. These are all within the purview of judicial discretion. Now, again, it is not a precedent, because the fact is that this case has gone on for years and years.
Okay.
Therefore, when the Supreme Court pronounced judgment, they did not make a distinction. They gave everybody time to surrender. It wasn't that they gave one person time to surrender and not another. They gave everybody time to surrender. Now, if they gave time to surrender, what has really been asked for is an adjournment of that date to surrender. And that is all that's been asked for.
Okay.
It is not a reprieve, it is not mercy, because the sentence doesn't get reduced at all.
But you're missing the
and
point.
All that happens
Forgive me,
is
I'm interrupting you again, because when Zebu Nissa asked for a reprieve till her pardon petition...
Date.
No, she didn't ask for an open-ended date. She asked for a reprieve till her pardon was considered by the president. That may not be open-ended necessarily, because whenever the president hears it... So it's the same thing. It is a similar adjournment as you're describing Sanjay's appeal. What's the difference?
Not really. Not really. I would use the distinction of the words adjournment sine die and adjournment for a specified period for a specified purpose.
I take your point.
Now, the fact is
I take your point. I think it's a good one.
Adjournment until a mercy is decided is unheard of, and that's never been done before, and that should have been a precedent.
Rensal De Silva, one could argue that by giving Sanjay Dutt relief on the grounds that otherwise the 300-odd crores riding on his films could be lost. The Supreme Court has ended up allowing commercial considerations to take precedence over the equal and fair implementation of justice. How do you respond to that argument?
See, Karan, I think we should just stop and think a while. When you're talking about humanitarian reasons, there is also, apart from the amount of money riding on a project as far as the producers are concerned, I think you should also look at the amount of technicians, the number of daily workers who end up on a film set getting paid or not paid, and it all depends on whether a film is completed or not. That, to my mind, is equally humanitarian. We all know what happens to films that are junked or shelved. A lot of the payment never ever reaches those people.
Can I interrupt? You know, you're making a compelling case and argument that, in fact, innocent people like film producers and film workers and technicians would suffer because if the films aren't completed, their livelihood would be at risk. And therefore, in fact, if relief has been given, it's been given with them in mind rather than with Sanjay in mind, because Sanjay is only the beneficiary. But what about the opposite argument?
No, I think, you know, Karan,
let me finish. What about the opposite argument that all of you who signed up Sanjay knew 20 years ago that he could end up in jail? And this was a risk you should have borne in mind and factored in much earlier, rather than hope for relief and reprieve at the point when he gets sentenced.
You know, Karan, you're right. I don't think that is that argument cannot be contested. That everyone should have backed away from signing Sanjay. We all signed him, I think, for purely emotional reasons, and I think the fact that we have long-standing relations with the man who we think is a good actor and star. But apart from that, I also think that, you know, what are we really asking for? We are not saying Sanjay Dutt is not going to jail. 4 weeks is not really going to make a major difference to his life. They will be added to the end of his sentence.
Oh, but just a moment.
If he starts,
just a moment. Just a moment. Can't that argument apply to Zebun Nisa Qazi as well? All she could say is that, what am I asking for? Give me time till my pardon is decided. I'm not saying that the pardon should take forever to decide. If the government is slow, that's the government's fault, not mine. But give me time till the pardon is decided. And if you then decide to send me to jail, this will be added on at the end of the sentence. The same argument applies to her as it does to Sanjay. Except you could say, as some are saying now, that she's poor, she's not a film star, she has no celebrity status. Sanjay is rich, Sanjay has influential friends, he's a celebrity. And the question arises, has celebrity status made the difference between the two? How do you answer that?
Karan, can you just let me answer this? Because I think I have a reason for answering this in a very precise way. Do you know the nature of filmmaking is such that it's a perishable commodity, really. Once an actor enters the frame as a character, we cannot reshoot this film with any other actor if it is too far gone. It is a junked film. Like someone made this comparison to me he said, you know, just listen to me. He said, if a heart surgeon was to kill his wife, does that mean that the court should not then allow him to go to jail because he has 7 more patients for the month? And I said, that's not the right analogy. The right analogy would be if the heart surgeon was performing surgery in the operation theater and the cops came and took him away and left the patient to half operated. That is the right analogy. So I think the Supreme Court judges have seen this.
Let me stop you there. You're making a good argument, but let's see whether it stands up as actually as unique as you think it is. I have Mr. Ramachandran sitting here. You've heard Mr. Ramachandran's views. Let me put this to you. If relief can be granted to Sanjay on the grounds that his producers or other film workers will suffer because the film won't be completed, then can't that logic be applied to other people as well? Because I put it to you, there are many convicts who are involved in, say, commercial or financial relationships where third innocent parties would suffer if they go to jail. There are many people who head NGOs who do valuable work for poor people where the NGO and the work would suffer because people have gone to jail. Therefore, the logic that applies to Sanjay and film workers could apply to industrialists and investors, to anyone.
Virtually everyone is involved in some economic or social activity which will get adversely affected if he or she goes to jail. That can't be a reason for allowing someone to fix a time or to choose a time when he will surrender to the law. Now, let's go to the surgeon example. Let's go to the surgeon example. If you remember, there was the famous eye surgeon of Delhi, Dr. N.S. Jain, convicted for the murder of his wife, Dr. Vidya Jain. He went to jail because he was such an eminent surgeon. He was given reprieves sometimes to be able to go out and perform those operations and come back. But there was no compromise on his surrender and serving his sentence.
So the Supreme Court, you're suggesting by implication, should have sent Sanjay to jail and then allowed him to come out to finish films for a brief period of time rather than give him a reprieve on those grounds.
That wouldn't have been at the Supreme Court's discretion. Once he surrendered, then it was for the authorities, for the government, to consider his case for remissions, reprieves, paroles, etc.
Let me pick you up on two other points. First of all, therefore, do you accept that in granting Sanjay a reprieve on the grounds that otherwise the film and the workers who are innocent would suffer, the Supreme Court could have unwittingly set a precedent that could apply to entrepreneurs who invest investors' money? When they go to jail, those investors are innocent third parties, they suffer. Or it could apply to NGO people who do critical work. When they go to jail, the work the NGO does suffer. This logic could apply to all of them as well.
And therefore, as I said in the earlier question, in response to the earlier question, they won't be able to follow this precedent.
I thought they've tied themselves in knots.
That's right.
Now, what about the point Mr. Arima Sundaram made? He says there is a distinction to be drawn between Zebun Esakezi demanding a reprieve till her pardon is heard, because that is a adjournment sine die without any date, and demanding an adjournment for a limited period, be it 6 months or 4 weeks. Do you accept that distinction?
I think it's a distinction without a difference. In one case, it's the president who has to decide. In the other case, you are asking for time. But in either case, the effect is postponement of surrender to the law.
And therefore, the quantum is not the question here.
That's right.
The question is one of principle.
That's right.
And in terms of principle, you think the Supreme Court has erred.
Erred. And egregiously erred, to repeat.
And egregiously erred. Mr. Sundaram, let me quote to you a text message sent to me today by Lieutenant General Raj Kadian, who has given me permission to name him a former Deputy Chief of the Army Staff. He says that the decision taken by the Supreme Court in giving Sanjay Dutt reprieve is like asking a guilty person to undergo punishment at his convenience. Many people would say that is precisely what the Supreme Court's decision amounts to. How do you respond to General Kadian?
Well, I would respond to it straight away that by saying that he appears to have got it slightly wrong because no reprieve has been given. Let's understand what the word reprieve means. Reprieve really is that he has been reprieved from suffering his sentence.
I think you're quibbling over words, surely, Mr. Sundaram.
No, I'm not quibbling over words.
Because the point General Kadian is talking about is that Sanjay is allowed to start his punishment when he chooses and when he wants, rather than when the judge determines.
Therefore, let us come to that to start with. The fact of the matter is, it is therefore not a reprieve, but a question of the date of serving the remainder of a sentence, not starting his sentence, remainder of his sentence. Because don't forget, he has already been in jail for a year and a half.
Yes, but that applies to Zebun Isakazi as well. That applies to everyone.
To all. It applies to all.
But you're not answering the critical question.
So what has really happened is, the critical question is, as Raju Ramachandran pointed out, normally when on the date of conviction in a trial court, the accused are in court and are taken into custody straight away. In a case like this, which has gone on for so long and people have been out on bail, and the case before the Supreme Court also went on for months on end, and it has gone on for a long time, because the sentence is coming on a given day, by which time people may be in the middle of something or the other. Which is exactly why time was given to everybody. Please allow me to finish. Just let me finish the sentence. Therefore, time was given for everybody to surrender. Somebody comes forward and says, look, for this particular reason, I need a bit of further time to surrender. Now, according to me, it's on the facts and circumstances of the case, which I can't comment on.
No, obviously
but
not.
I can
but
say
you're missing the
that
point.
Judicial discretion allows you to decide
Of course, judicial discretion allows you to decide everything, but that doesn't mean to say that discretion has been correctly exercised. That's what we're questioning, not the existence.
It has.
We're not questioning the existence of that discretion. We're questioning
the problem is that your comparison is odious.
I'm not sure
you cannot compare the way you are between the two cases.
No, well, I'm not necessarily comparing with Zebunissa now. I'm bringing up the fact that the Supreme Court, wittingly or unwittingly, has set a precedent, as Mr. Ramachandran agrees, for a situation that could apply to other people. An industrialist who is sent to... Let me finish. You don't even know what you're answering at the moment. When an industrialist is sent to jail in the middle of setting up a major enterprise, he's handling the money of innocent investors. There may be hundreds and thousands of people who will be innocent and will suffer because the industrialist has gone to jail. Why can't he turn around and say, delay my sentencing by 6 months, let me set up the enterprise, all these people who've invested in me and trusted me won't suffer, and then I'll go to jail. That logic now will apply there too. What would the Supreme Court say if an industrialist brings that example up?
No, I think, Karan, there is a difference.
Mr. Ramachandran straight away, allow me to finish please. I can answer Mr. Ramachandran straight away by asking him a simple question. Is it not a fact that in cases where there have been financial investment companies which have lost money, that when the person has been arrested and then asked for bail, a conditional bail is given on condition that he goes about trying to resurrect whatever it can and deposits an amount of X 2 crores or 5 crores or 10 crores every 1 month? Has that not been done in the past?
Mr. Ramachandran.
If that has been done in the past,
answer itself is the answer. Those are cases of bail. This is after conviction by the final court. Surely there's a difference between bail and final conviction.
Gentlemen, I'm going to take a break at that point. I want to come back after the break and turn to an issue that I think is one of equal importance to a lay audience. Has the Supreme Court, in the way it's handled the Zebunissa case and its reasons for rejecting her plea that her sentencing or going to jail should be delayed till the mercy petition is handled, and the way it's handled Sanjay Dutt, tied the Supreme Court in knots? That's in a moment's time. See you after the break. Welcome back to The Last Word. We're discussing Sanjay Dutt and the Supreme Court. Mr. Ramachandran, I want to take up this question whether in handling the Zebunissa Kazi case yesterday and Sanjay Dutt today, the Supreme Court has actually tied itself in knots. When the Supreme Court refused her request for relief till her pardon is heard by the President, they said that to agree would be to create grounds which thousands of people could then use as a precedent. But as we've just discussed in part 1, the basis on which they've given Sanjay Dutt 4 weeks relief also creates grounds which many people could use. So in handling the two cases, has the Supreme Court tied itself in knots?
Let's remember one thing. These were two different benches of the Supreme Court. The bench which denied relief to Zebunissa.
But the same court nonetheless.
That's right. That's right. When they said that if we grant you relief pending consideration of your case for pardon, we'll be setting a wrong precedent, I think the court was correct. Here, the court was clearly wrong. These are two contradictory approaches by two different benches.
And in addition, in the Sanjay Dutt case, as we argued in part 1, they've set a precedent that others could now argue on the grounds that if I go to jail, innocence will suffer, so give me time. And so what I'm saying to you is, even though it's two different benches involved, it is the same court because they both act in the name of the same court. Have the two benches tied up the court in knots?
Yes, it would appear so. But then the court can always, in a future case, when this is cited, say that no, that was exercise of discretion in one case.
All right, the court would have to get itself out of the knot that it's tied, but until it does so, it's tied up in knots.
That's right.
Krushanshu Mukherjee, sadly, you've only just been able to join us because of terrible weather in Calcutta. Let me ask you one critical question. As you view the court's handling of the Sanjay Dutt case and the earlier Zebunissa Kazi case, do the two represent a good day for Indian justice or a sad day? Have we seen justice tempered with mercy and compassion, or justice that's swayed by bias?
From the point of view of the judiciary, let's forget for the moment the points of view of the two accused. From the point of view of the judiciary and for the legal system, it's a terrible day for India, because one of the principal axioms of jurisprudence, that everybody is equal in the eyes of the law, has been violated. The two cases, forget the legal niceties, the two benches involved and the pleas were different, actually contradict each other. So in fact, to use a rather colloquial expression, the Supreme Court has got itself in a bad twist.
All right. I will leave those famous words as the last words on this show. I'll apologize to both Renzel de Silva as well as to Arima Sundaram that I couldn't come back to them, although I will add, for the sake of the audience, that they would have spoken against the points made both by Raju Ramachandran and, of course, by our friend from Calcutta, the opinion editor of The Telegraph. But unfortunately, we've run right out of time, and my apologies. Goodbye. Good night.